Good morning once again, honorable members of parliament and the viewing public. We did have a technical issue that we had to resolve before going into the meeting. I'd like to thank the technical team for doing that. So I will now go back to once again to the notifications from members of parliament. We had a notification from MP Bijlani and MP Rayon Peterson that they will be absent. However, MP Bijlani did say he will still make an effort to attend. And MP Duncan is also running late, as well as MP Heyliger-Marten. At this time, on behalf of the Parliament of St. Martin, I wish to express our heartfelt sympathy once again to the people of Turkey and Syria, as the death toll has risen to over 12,000. So we, as was mentioned yesterday, we do understand and can imagine the difficulty that they are going through. And to all the people of Turkey and Syria, both there and in St. Martin, our heartfelt sympathy. I also have a notification as a follow-up request that I've been asked to deliver on behalf of the chairman, and that was based on the request that if it can be indicated which, if any meetings are, this is from MP Wescot-Williams to clarify. MP Wescott, your question was if it can be indicated which, if any meetings are still outstanding for ministers to return to provide Parliament with answers to questions we have posed on different subjects. I have received from the Secretariat a list of such meetings. In total, we have 7 meetings outstanding. It would be 8 if we include this meeting. So just for posterity's sake, it's actually 8, including this meeting. And the ministers that have to return to answers, there's 1 for the Prime Minister, 1 for the Minister of TIAT, 2 for the Minister of VSA, 2 for ECYS, 2 for VROMI, 2 for Justice, including this meeting, and 1 for the Minister of Finance. If you add those, they will add up to more than 8. However, keep in mind that, for example, the Minister of VSA is coming with the Minister of ECYS, and there's also an instant where the Minister of ECYS will be coming with the Minister of VROMI and the Minister of Justice with the Minister of VSA. So 8 meetings total with approximately between 1 and 2 instances per minister. I hope that answers your question, and if you have any further questions, we'll be happy to try to provide the answers. Are there any notifications from members of Parliament at this time? I see MP Wescot-Williams.
Thank you, Mr. Chairman. Mr. Chairman, a good morning. A good morning to you, our support staff, my colleagues, colleague MPs, and of course a good morning to the Minister of Justice and her entourage here this morning. Good morning, St. Martin. Thank you for tuning in to this meeting regarding the issues at the different areas, the prison, etc., and some of the matters that have been brought forward by inmates and representatives of inmates. Mr. Chairman, thank you so very much for responding so quickly to my request of yesterday. Thank you for the information provided. And since that has gone so smoothly, for our next meeting, maybe the outstanding questions that members of Parliament have out there to the ministers, as you know, that's tied into not a formal amount, but amount of time, but in any case, if that could be done. However, Mr. Chairman, I'm going to be quite short. I don't want to overuse the possibility of notification. So I just want to make it more of a heads up to the President of Parliament, actually, and that had to do with the meeting of yesterday, in which it is my position, and I look forward to hearing from the President of Parliament, that he unjustifiably did not allow me to make a point/proposal of order. But that's just a heads up, and I'll address the President directly. But what I do want to say on a happier note is I want to commend my colleague, MP Ludmila de Wever, for chairing the Finance Committee meeting yesterday. And I say this because it was about time that respectfully and tactfully the minister in question be reminded of his role here in Parliament. So the references about which members of Parliament were here or not here, or who served for 5, 10, 15, or 20 years, those references were completely out of place, and very tactfully, the minister was told that by the chair of the Finance Committee. So I really want to commend her, and I commend her because more and more from a few, just a few, not even a handful of members of parliament, this kind of misogynistic behavior that is being displayed. I commend the chairlady of the Finance Committee for basically putting her foot down where that is concerned. And unlike the appointments to the chair of parliament, when it comes to the committee, that happens only when we have a new parliamentary year. So you do you. And it was really good, and I commend you for that. And I want to make a prediction, a couple of them. One, we're going to see a proposal coming as to how to deal with notifications. So until that time, I'm going to use it as it is right now and try to see how members who are committee members, how they can be replaced. So I look forward to when those come, and we will see. Thank you, Mr. Chairman. Really, thank you for allowing me to mention those points. Thank you.
Thank you, MP Wescot-Williams. Just two quick follow-ups. Can you please repeat what your follow-up question was regarding questions or answers? I didn't quite. Oh, yeah.
I can't thank you enough for allowing me the opportunity. I had asked if we can also be provided a listing of what can be considered outstanding questions by members of parliament to the ministers, please, because what we have seen is that sometimes the answers are incorporated into a meeting, and then it's not really clear, and we don't have them in writing, etc. So if that overview can be provided, I would be most appreciative of that effort. Thank you.
Thank you, MP Wescot-Williams. Next, MP George Pantaflet.
Thank you, Mr. Chairman. Good morning to the chair, my colleagues in Parliament, Okhrified, of course, our Minister of Justice, Richardson and her support staff, persons who are viewing this meeting. Mr. Chairman, I'm happy to hear that some changes will be brought to notification, because for a long time I found that persons have used it in order to create their own agendas. And Mr. Chairman, I was just going to stand to mention something here which I was happy to see, and it had to do with a motion in the second chamber of the Netherlands, where it was voted down by the second chamber because a member of the PVV, Mr. Peter Bosma, wanted to ensure that Mr. Tula's name be not part of the remembrance history of the Dutch. And his argument was that because during the uprising, one teacher in a classroom got killed. One teacher in a classroom got killed. And therefore, because of that, he did not want, or he came with a motion, the PVV, in order for them not to put Tula's name as a remembrance in the Dutch history. Mr. Chairman, I mean, how much hypocrisy, or how hypocritical is that? How hypocritical is this, Mr. Chairman? But I won't go there any further, because those who are listening should know exactly what I mean. You are talking about one, I mean, even though a life is important, you're talking about one individual in comparison to how many millions and so on were brutalized, Mr. Chairman, during slavery. So I'm happy to see the second chamber used their authority and their sense to vote down that motion. Mr. Chairman, I want to also take this time to congratulate the coalition, because what we did when it was establishing the presidents and the vice chairs for committee, we did not play politics and remove the then chair of finance. We voted for them to remain, Mr. Chairman, because we feel that should be doing a good job. So therefore, Mr. Chairman, we didn't play politics with that matter. So we also want to congratulate the coalition and also thank the president of the committee for being a professional. Thank you, Mr. Chairman.
Thank you, MP George Pantaflet. Are there any other notifications? That not being the case, thank you, members of parliament, for your notifications. We have as agenda point for this meeting the discussion regarding the flow and management of the inmates at the Point Blanch Prison. This is IS 363, dated January 19th, 2023. This meeting was requested by the MPs Heyliger-Marten, Wescot-Williams, and Emmanuel. We go over to the agenda point. On the 19th of January, Parliament received a letter, IS 363, dated January 19th, 2023, from the members of Parliament Heyliger-Marten, Wescot-Williams, and Emmanuel, with the request that an urgent public meeting of Parliament be convened with the above-mentioned agenda point. The presence of the Minister of Justice was also requested. The meeting was convened on January 25th, 2023, during which the requesters of the meeting were given the opportunity to elucidate their request. After a presentation by the Minister of Justice, members of Parliament posed questions to the Minister in the first round. The meeting was then adjourned to allow the Minister time to prepare the answers to the questions posed by members of Parliament in the first round. Today, the Minister of Justice, Ms. Anna Richardson, has returned to Parliament to provide the answers to the questions posed by the members of Parliament. Hence today, the continuation of this meeting, this public meeting, number 12. Before giving the floor to the Minister of Justice, there was apparently quite a number of questions. After the first 40 questions, I'll take a brief 10-minute adjournment, and then after we'll continue with the rest of the questions, just for you to take note of that, members of Parliament, before we then go over to the second round. At this time, I'd like to give the floor to the Minister of Justice, Ms. Anna Richardson, to provide the answers to the questions posed by the members of Parliament in the first round. You have the floor.
Mr. Chairman, members of Parliament, Secretary General, Prison Director, the Head of Judicial Affairs at the Ministry of Justice, support staff, the viewing and listening public, and a special good morning to all senior citizens. Through you, Mr. Chairman, please allow me to answer the questions posed to my person on January 25th during that public meeting number 12. First questions that I will be answering are those from MP Heyliger. Please inform the Parliament on how many cases related to St. Martin Prison has the Dutch Kingdom lost in the European courts for violating human rights of inmates. Answer: there aren't any cases related to the Point Blanch Prison for violating the human rights of inmates. As a point of clarification, on April 25th, 2017, Ms. Corallo's case, hereafter the applicant, submitted an application to the European Courts of Human Rights, hereafter the courts, under Article 34 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. The applicant complained that the conditions of his detention at the Philipsburg police station had amounted to treatment prescribed by Article 3 of the Convention, which reads as follows: no one shall be subjected to torture or to inhumane or degrading treatment or punishment. On October 9th, 2018, the court declared that the complainant under Article 3 of the Convention concerning the conditions of the applicant's detention at the Philipsburg police station admissible and the remainder of the application inadmissible. In a recent memory, the above case has been the only court case related to St. Martin in which a complaint by an applicant of the violation of the European Convention for Protection and Human Rights and Fundamental Freedoms are declared admissible. Capacity. Is the Minister familiar with Article 1, Paragraph 32 of the Criminal Code, which states that it is the Minister that sets the conditions for early release of inmates? Is the Minister familiar with this article, and is she executing her mandate to release inmates in order to allow for a proper flow of inmates into the Point Blanch Prison? Answer. As a point of clarification, it is not Article 1, Paragraph 32 of the Criminal Code, as the MP referred to, but in the entire Section 3, Article 130 through 140 of the Criminal Code that covers conditional release. Yes, as Minister, I am familiar with the legal framework of conditional release. Slide 31 of my previous presentation addressed the subject matter of conditional release and early conditional release. As a Minister, I have been steadily granting conditional release and early conditional release to inmates who fulfill the legal requirements as such. In the period from January 1st, 2023 until today, February 9, 2023, 5 inmates have been granted early conditional release. As I mentioned in my last visit to Parliament, as quickly as reviews are done and persons are granted early release, capacity quickly refills due to our high rate of crimes being committed on the island. According to 2 to 3 years ago, the prison capacity moved from 70 to 80. What justifiable reason was there for this increase? Are there new prison cells that we are not aware of? The capacity as a result of Hurricane Irma and Maria slightly decreased due to damaged cells. However, these have been repaired over time, and the current capacity for male inmates is 90. There are 40 housing cells for males that can be occupied by 2 inmates maximum. I said that. What are the minister's short-term solutions to tackle prison capacity issues? Unfortunately, the sad reality in St. Martin is that the rate at which crimes are being committed, the severity of these types of crimes that are being committed, and also, thankfully, the success rate of our law enforcement authorities in apprehending and prosecuting the perpetrators of criminal offenses currently outpaces any limited capacity that is created by the measures that we undertake to tackle capacity issues. As I mentioned in my last presentation to you, there is an overall detention policy in place which is aimed at preventing overcrowding. This includes a cap on the maximum number of detainees per cell, the use of alternative accommodations such as the youth facility that was reopened in 2019, the opportunity to electronic monitoring, ankle bracelets, and if possible, conditional release when certain criteria are met. In this respect, frequent consultations are held between the Ministry of Justice, the prison, the Public Prosecutor's Office, and the Parole Board or Parole Office to assess the situation and decide on the most appropriate measure. As much as I would like, there is no immediate remedy or solution to our society's issue, and this is not for the lack of trying. In addition to the aforementioned measures, I can inform you that since coming into office in March 2020, I have considered various courses of action to address the capacity issues, such as exploring the possibility to approach countries of origin of undocumented inmates in the Point Blanch Prison who would then be repatriated to their home country to sit out the remainder of their sentence and be prohibited from returning to St. Martin for a specific number of years. The biggest challenge here is that of treaties. We need treaties to be able to to work with countries and to have these persons return to, the inmates return to the countries they hail from. We have to keep in mind that the prison sentence must work as a deterrent for crime in St. Martin, and equally important, victims of crimes must know that justice is being served for the acts committed against them and or their families. In addition to the previous, on more than one occasion, I have consulted my colleague ministers in the kingdom to discuss possibilities of transferring St. Martin inmates or inmates at the Harvey Bay facility to other parts of the kingdom. These talks are ongoing. Ultimately, this is St. Martin's problem that must be solved. There is no quick fix. What does offer the best perspective is the trajectory that we have embarked on with our partners, UNOPS, and the Netherlands with the new prison project. I have requested that the transitional facility, which will house the inmates in the interim period while the demolition of the old prison takes place and the new prison is built, include extra capacity above the number that we currently have. UNOPS has indicated that at the end of phase 1 of this project, which is projected to take 20 months, a transitional facility will have been procured. Question: is the minister aware that because the prison is at its maximum capacity, new detainees at the police holding cells remain there longer than the allotted 10 days? This is a blatant violation of Article 3 of the ECHR. How will the minister address this problem? Following the court's judgment in the case of Corallo versus the Netherlands, a policy was established by the Public Prosecutor's Office to not detain any persons longer than 10 days in the facility of Philipsburg Police Station. It should be noted, however, that the view of the ongoing pressure on the detention capacity in authorities are sometimes faced with difficult dilemmas. Sometimes it is inevitable to send people away from the remand center due to insufficient capacity. This happens after careful consideration and consultation between the authorities involved. It shows that in many cases, pretrial detention in the Huis van Bewaring at Philipsburg Police Station was suspended or terminated after 10 days. In a small number of cases, the duration of the detention did exceed 10 days. In some instances, the detainees' representatives submitted the situation for judicial review. The judges then visited the facility in order to form an opinion on the conditions. In none of those cases, they found a violation of Article 3 of the European Convention for the Protection of Human Rights and Fundamental Freedom, or ECHR. Though in some cases, an order was given to transfer detainees to the regular Huis van Bewaring in Point Blanch as soon as possible. Correct me if I'm wrong. The minister is currently retracting the MBA for the police cells. How far along is this? If there is indeed an MBA for this, we would like a copy of this MBA and the purpose behind creating this MBA. The ministerial regulation of December 21 or 21st, 2011, a section of the police cells was appointed to the Huis van Bewaring. The decision taken by then Minister Duncan at the time was based on the urgent need of extra cells to carry out renovations at the Point Blanch Prison. The ministerial regulation was published in the official publication AB or AB 2012 number 3. If needed, a copy can be provided to Parliament. Internal discussions have been taking place and will continue to take place to discuss Harvey-based status of police cells. However, no decision will be taken without having a clear insight into the complete set of implications for all parties involved. What are the minister's short-term solutions to tackle safety breaches to protect both the inmates and prison guards? There are a number of aspects that directly or indirectly contribute to an increased level of safety and security within the detention facility. The first is the physical safety of the institution, such as security systems, as well as infrastructural safety. In terms of physical safety, in 2021, each cell received a new heavy-duty lock. In 2022, the fire alarm system and perimeter lighting were reinstalled. September 2022, 10 handheld scanners were purchased to be used during the access control and cell searches. They have been quite effective in improving the findings of contraband. In 2023, it is the prison director's intention to purchase additional equipment to decrease the possibility of impact and increase the overall safety level, such as new detention ports, new portophones, and more. A second aspect of improving the safety within a prison is the dynamic security that is a result of the professionalism and quality of the prison guard and a positive relationship developed between inmates and guards. As mentioned in my previous presentation, a positive development in the area of personnel is the Prison Guard Training Program that started in September 2022. In cooperation with the Dutch custodial agency in the Netherlands, DEE, all prison guards are given the opportunity to join the training that covers different areas: integrity, self-defense, security, aggression regulation, prison law, positive motivation of inmates, and more. Thus far, 5 groups consisting of 10 guards have already completed the first module of the training. All prison guards are expected to complete the training by the end of 2023. The skills acquired during the prison guard training is required to be able to respond effectively to incidents within the prison walls. This training includes de-escalating inmate-to-inmate violence and/or violence against prison staff, proper self-defense techniques, restraining aggressive inmates, and more. By measure, we are already seeing that these trainings are proving effective. In addition, these trainings also include courses on developing positive relationships and communication with inmates through motivational treatment. In instances where staff are not properly trained in establishing and maintaining relationship with inmates, they are more likely to be vulnerable to conditioning and manipulation by inmates. A third point of improvement, which has recently been completed, is the reconstruction of the solitary confinement cells and adding an additional small airspace for those confined. These reconstructed cells allow for a better isolation for inmates on confinement when necessary. Lastly, upon arrival of inmates are screened and a risk assessment performed. Inmates are then placed based on security level, gang affiliation, and other security factors. This is an important existing protocol that is necessary to manage gang-related violence. Ankle bracelets. Why are only 2 inmates on ankle bracelets? There are several contributing factors as to why more ankle bracelets are being used. 1, the prison population consists of a number of undocumented persons, and when the opportunity arrives for them to be released, they are immediately turned over to the Immigration Department, and the laws that governs residency are applied. There is not a large pool of inmates who are currently eligible for early release, and many who have been released in the past did not meet the requirements for ankle bracelets. Inmates who do not have residency on the Dutch side of the island are not candidates for ankle bracelets, as cross-border brings jurisdictional restrictions. The ankle bracelet option can and will be used when inmates meet the requirements. Who monitors the ankle bracelets? Is it done internally or is it outsourced? To whom is the outsourced, and what credentials do they have to execute this service? The Ministry of Justice is using the monitoring platform and hardware of Buddy Limited, a renowned international company based in the UK that specializes in providing electronic monitoring services. Curacao, Bonaire, and the Netherlands are also using the hardware and monitoring platform of Buddy Limited. The Point Blanch Prison and Probation Office have an important role in the monitoring, responding to alerts, and providing technical assistance in the electronic monitoring process. Why hasn't the ankle bracelet policy been reactivated? Currently, you are following what is listed in the criminal code. It is assumed that the ministerial regulation, electronic monitoring, is meant here, which was revoked in 2015. The articles in the criminal code provide a sufficient legal basis to use electronic monitoring as a special condition. Unlike the ministerial regulation, there is no specific time limit determined for the use of the electronic monitoring. Therefore, it is less rigid. When an inmate is processed as an early release candidate with electronic monitoring, the 8A guidelines and rules of the probation office are being discussed with the inmate, and they formally have to indicate if they agree with the guidelines and rules. The criminal code, in combination with the 8A guidelines and rules of the probation office, provides an appropriate framework for electronic monitoring as a condition of early release. How many persons are on the waiting list to serve their time? As per October 2022, based on the information provided by the prosecutor's office, an amount of at least 136 people are waiting to serve their time. How many on the waiting list are illegals? At this time, the prosecutor's office or services is not focused on the status of persons on the waiting list. As such, this information cannot be provided at this time. How many of these illegals have received a sentence under 5 years? At this time, an answer to this question is unavailable. How many in our current prison are illegals and have a sentence less than 5 years? Of our current population, there are 24 inmates that are undocumented. Of these 24 inmates, none have received a sentence less than 5 years. What is the latest court verdict on the pending list right now by date? At this time, an answer for this question is unavailable. How many inmates are first-time offenders? Of the inmates incarcerated, an amount of 45 inmates are first-time offenders. How many are between the ages of 18 and 25 that are first-time offenders? Of the inmate population, there are 11 inmates between the ages of 18 and 25 that are first-time offenders. How many are nearing two-thirds of their sentence? There are 4 inmates in 2023 that are nearing two-thirds of their sentence and 5 in 2024. Is there a policy relating to good behavior of the inmates? If so, based on what criteria are they being evaluated? Who oversees this criteria? Is this policy currently active? Yes, The criteria include, but is not limited to, the observation as follows, or such as the amount and types of violations, if any, that the inmate has performed or executed while incarcerated, participation in daytime programs such as educational and work programs, overall behavior towards the guard or general inmate conduct. This is done by social workers with advice to the prison director. The benefit of good behavior can include participation in Family Fun Day, Family Treats Day, and other high-valued privileges. How is the minister informed of upcoming release dates? Who sends it to the minister? Is this done monthly or weekly? The Department of Judicial Affairs presents the minister with the advice and the national decree as it relates to candidates for early and/or conditional release. The frequency differs as it is based on the inmate's irrevocable verdict versus time served. What exactly does this report entail? A conditional release file includes an advice of the prison, including the verdict, reprimand reports, if any, an advice of the probation office, an advice of the parole board, and additional relevant documents. Based on the complete set of documents, a decision is made. What is the exact function of the parole board? The function of the parole board in the process relates to conditional release is determined in the previously mentioned Section 3 of the Criminal Code. The parole board advises the Minister of Justice about the conditions of early or conditional release, the suspension or denial of conditional release, and the revoking of conditional release when an ex-inmate violates his or her conditions of conditional release during an early release probation period. What criteria do they use to release inmates? The first criteria is that an inmate must have an irrevocable verdict. If there is still an appeal in the criminal case, the inmate cannot be processed for early release. For early conditional release, it is further relevant which percentage of the complete sentence has been sat out. The advisory bodies in the early release procedure, such as the prison, the probation office, and the parole board, take into account the behavior of the inmate during detention, the mental health of the inmate, the risk for society if the inmate is released, if there is appropriate housing available after release, the chances of recidivism, work opportunities after release, support by family, the types of guidance or treatment that will be necessary after release, if the inmate is willing to comply to the conditions of conditional release, and so forth. On average, how long does the process take? If there are no complication factors based on the relevant aspects described in the answer to the previous question, a file can be completed within 3 to 4 weeks. Are there any entities involved in the release process? If yes, who are they? Please walk us through the process of a release. The early release work group discusses the early release dates of inmates. Based on this discussion, the prison inmates the first part of the early release file. The social workers of the prison invites the inmates for an early release intake and gather all relevant information to advise adequately. When the advice of the prison is approved by the prison director, it will be forwarded to the probation office. The probation officer meets with the inmate and speaks to the family and support networks of the inmate. When electronic monitoring is suggested as a special condition, the ATAG technical team pays a house visit to the home of the inmate or that the inmate will be living in after release to check if it is technically suitable for ATAG. For example, if GPS signal can be received inside the house. When the probation office has sufficient information to advise about the special conditions, an advisory report is drafted. That report is checked and signed by the director of the probation office, after which it is sent to the Department of Judicial Affairs. The Department of Judicial Affairs provides the CCR or the parole board with the advisory report of the prison and probation office. Based on those files, the CCR submits an advice. If deemed necessary, the CCR can request to hear the inmate. Once the CCR has submitted their advice, the Department of Judicial Affairs prepares a draft ministerial decision. The complete early release file with the draft decision is presented and discussed with the minister. Once a formal decision has been taken by the minister, a copy of the decision is sent to the relevant stakeholders, and the moment of release can be further prepared. The procedure is slightly different when no special conditions can be imposed because the inmate will not be residing on St. Martin after release, or if electronic monitoring is not imposed as a special condition. House rules. Can we expect an updated modern rule book? The House rules were amended in 2022. The prison director established the new House rules, and these have been disseminated amongst the inmates and staff in October 2022. The new House rules are available in English, Dutch, and Spanish. Compared to the previous version of the House rules, a substantial number of amendments have been made. Firstly, outdated information has been removed and replaced with accurate information, for example, about conditional release. In addition, more elaborate information has been included on certain subject matters such as visits, rights of inmates, personal belongings, and the use of cell space. And finally, new information has been added on different subject matters such as prohibited items, electronic devices, and hourly rates for labor by inmates. A copy of the amended House rules can be shared with Parliament if so desired. Is the work outside the prison program something the minister would consider executing? The prison management team has been in contact with respective representatives from the Ministry of Romy and are discussing a work program for the inmates to clean the roadways, erecting road signs, and so forth. With the assistance of the electronic monitoring system and under supervision of prison personnel, the prison management is currently in the process of reviewing the following stages for eligible inmates to participate in this collaborative program as a pilot. This initiative is the beginning phase of all factors such as safety and security, personnel manning, type of work, location, eligible inmates, and more must be considered and assessed. Can we include VK-S in supporting this initiative, or must they be trained? If a training is needed, what training is this? What would this training cost? The VK-S has and continues to support Harvey Bay under a third-party contract. Their main task includes guarding the prison perimeters. The VK-S guards do not have any direct contact with inmates and do not have any jurisdiction and or authority to execute such tasks. Can Parliament be provided with general list menu that is being preserved to the inmates? Several members of Parliament have asked about the accuracy of the photos and information shared in the previous presentation. To answer these questions on how current the photos are of the meals served, I have requested the document be prepared food over the last week. This gives us a good overview of the meals that are prepared for the inmates, taking into consideration the dietary needs and other restrictions. In addition to this, an overview of the weekly meals can be shared with Parliament if desired. The chef and the inmates who are a part of the cook team at the prison, paying attention to the statements made in Parliament, opted to share as well and honor the minister's request. I'd like to draw your attention to the date and time that is listed on these photographs for accuracy. I would have liked for a video that was also shared with us to be able to be played, so the element of doubt could be removed. But they are quite proud of what they prepare on a daily basis for the inmates, and it is now on screen. Do they get fruits or yogurt? Under normal circumstances, inmates receive fruits as often as possible. Yogurt is not provided by the prison to the inmates. However, there is an extensive list of foods, items that inmates can purchase themselves from the canteen list. What times are meals served? Breakfast at 7 a.m., lunch at 11:30 a.m., supper before 3 p.m. to be eaten when wanted or desired. What time does the kitchen close? The kitchen closes at 3:30 p.m. However, Harvey Bay is currently has a space under construction in the recreational room where the inmates will be able to reheat and or cook their own food. This space is nearly completed, upon which inmates will be able to use it during their recreational time. Whose responsibility is it to serve the inmates their meals? Under normal circumstances, the inmates who work in the kitchen serves other inmates their food under supervision of guards as part of their task. However, under the rare circumstance of a strike where inmates are being forbidden to work by the leaders of the strike, the guards are then subjected to share out the food. How many medical staff is there on the premises? Currently, there are 2 nurses, which corresponds to the number of nurses permitted by our present function book. In addition to, the facility is visited by the contracted medical doctor on a weekly basis. Is there a set time the nurses are at the prison? If yes, what are these set times? The nurses are available during regular office hours and therefore are on call, and thereafter are on call. The prison's medical staff is on call 24/7 and responds to emergencies in the promptest manner. Standard procedure: medical intake by the doctor, not nurse, within 24 hours. Is this currently being done? And does every single inmate incarcerated in the prison have a record showing that their medical checkup has been done within 24 hours of their arrival? Though they may not be evaluated by a medical doctor within 24 hours of arriving at Harvey Bay, they do go through a medical evaluation by medical doctors prior to arriving at Harvey Bay. This is done at the Phillipsburg Police Station. Upon arrival of each inmate at Harvey Bay, the nurses carry out a brief medical assessment. This includes discussing their current medical issues or important medical history that requires follow-up or impair the inmates. A follow-up in-depth assessment is carried out within 1 to 30 days upon arrival. The in-depth medical assessment includes visual observation, general assessment of medical history, mental health assessment, a blood test, which generally includes an HIV screening. However, as previously mentioned in my presentation, there have been challenges with carrying out blood tests at the lab for inmates who are not in possession of an identification. This is a requirement to carry out the lab tests. The blood tests are not mandatory and are carried out on a voluntary basis. It is the prison director's intention this year to increase the focus on medical care at the prison. His plans include refurbishing the medical room, as well as updating the medical protocols, such as the medical intake and as described above, medicine distribution, and more. In the event that the nurses ascertain a medical injury and or conditions that need to be tended to by the doctor, the inmate is referred to the doctor, who does the follow-up consultation and treats them if necessary. The doctor is present on a weekly basis and is on call for emergencies that require his intervention and services. Lastly, all inmates have a medical dossier that also includes the information gathered during their intake. This is confidential information. Does the medical staff provide inmates with medication on a daily basis? It is not established by law that inmates should receive medication on a daily basis. Currently, medication is provided on a needed basis. Inmates are provided with information on how the medication is to be used. This is done with the intention to promote autonomy and mirror the community pharmacy model. The inmates are always monitored by the doctor. Correct me if I'm wrong, but there is currently a large number of inmates being prescribed Xanax. What is the reason for this? My main concern are the long-term side effects. They can also be addictive. Is there a control mechanism in place to control the prescription period? The doctor prescribes Xanax to inmates that suffer from insomnia. This is always monitored and evaluated by the doctor so that prescription of Xanax can be discontinued where possible. Currently, Xanax is not being prescribed as this is not being produced by factory. It is unknown when the production will recommence. Can VKSers also participate in this training? Whilst we appreciate the support that VKS provides to the Ministry of Justice in various capacities, the role and responsibility and authority of a prison guard significantly differs to that of a VKSer. If a member of the VKS program is interested in becoming a prison guard and work directly with inmates, this will require undergoing an application process as well as a certified training that is being administered by the Dutch Custodial Agency of the Netherlands. Has said inmates who is about to be released received anything in writing from the minister why he has not been released to date? Is there a letter prior to the minister discussing this publicly? Yes, by letter of January 24, 2023, I informed the inmate in writing about the status of his early release evaluation. He was also provided with the opportunity to meet with his family in a private setting to discuss the matter. Mr. Chairman, this brings me to the end of answering the questions of MP Heyliger.
Thank you, Minister. Members of Parliament, I'd like to take an adjournment until, let's say, till 25 past, and then we'll return with the rest of the questions and answers to the questions. We'll be back at 11:25. Good morning, honorable members of Parliament, Minister, and those viewing. We had an adjournment during the time where the Minister was still asking questions. However, she still has, answering questions. She still has some other answers to provide to the members of Parliament before we go over to clarifications. So at this time, I will allow the Minister to continue with the answering of the questions from members of Parliament from the first round. You have the floor.
Chairman, thank you very much. I would now move on to answer questions of MP Emmanuel. These questions are the majority of the questions I'll just like to state of MP Emmanuel. Many of them had to do or was posed to the UNOPS group, and so the answers that I would give would be responses that I received from same. Okay. Question 1, by means of a ratio, what is the prison guard to inmate ratio? How is prison manned given that the prison is understaffed? There are 68 filled prison guard FTAs. However, from an operational perspective, the day-to-day ratio is a number that fluctuates based on attendance. How many prison officers are currently manning the prison? Currently of the, I said the number 68 above, it's actually 64. Currently of the 64 persons that are employed at the prison as prison guards, 43 are deployed. The remaining number of guards are on long-term sick leave or have been transferred to other departments over time. Of the 43 deployed prison guards, 24 guards are deployed at the Point Blanch Prison, 11 are deployed at the MLC facility, and 8 are deployed at the police holding cells. These persons are divided into 3 to 4 shifts per day, depending on the facility. Noteworthy, guards utilizing sick leave does negatively impact the ability of manning the prison. Can the Minister provide an explanation in the difference between jail versus in prison? Well, I sought the answer from Google, and it says the following. While jail and prison are sometimes used interchangeably, they are two different types of incarceration. Jails are typically used to detain people awaiting trial or sentencing, and prisons house people who have been convicted of a crime. Is it the Ministry of Justice or the prosecutor's office that is responsible for your care when incarcerated? Up to today, the public is still not aware of how the gun was smuggled into the prison under the watch of the prison. As stated in Article 13 of the National Ordinance Establishing Principles of the Prison System, the upper management of the institution rests with the minister. The daily management is of that of the prison director. What type of medical care do prisoners receive in the prison? The ministry currently has a contractual agreement with a general practitioner who visits the inmates on a weekly basis to execute the necessary medical evaluation and administer medical care as needed. By extension, there are 2 nurses who are on the premises on a daily basis to support said medical service. What type of medical facility is available at the prison? Is there any type of medical facility at the Phillipsburg holding cells? The Point Blanch Prison currently has a medical intake room or sick bay. It is important to note that prior to 10-10-10, the prison facility was built in 1990 and was intended to be a house of detention, Huis van Bewaring, and not a prison where one is expected to have an infirmary. There is no designated medical facility at the Phillipsburg holding cell. Within the first 10 days of an inmate's stay, the incarcerated are assessed and cared for by a doctor. What type of medical procedures are carried out at the prison or any locations? I reiterate the fact that the facility was intended to be a house of detention, not a prison. As such, it is not outfitted with an infirmary. Therefore, there are no medical procedures carried out at the prison facilities other than medicine distribution, wound treatment, syringe application, and consultation. Inmates who may require medical procedures are referred to the physician or taken to the medical center. In terms of death at the holding cells, in terms of the death at the holding cell, he was given medication. Who supervises these cases? Was the doctor present at the time? Was his medical report given to the individual? Who facilitates these medical procedures to the individual once they are in custody of detention facilities. This particular matter you are referring to is still an ongoing investigation, and as such, no information can be divulged. However, as previously indicated, the medical file of all persons that are within the detention is kept in confidential spaces. It is provided to the nurses who manages this and the doctors at the House van Bewaring if the person goes on that far. Relating to the strike, who is responsible for hygiene and sanitation in terms of cleaning at the prison holding cells, and MLC? The prison is ultimately the responsibility, is responsible for the sanitation and hygiene within the detention facilities. Under normal circumstances, as part of the rehabilitation and work possibilities, designated inmates carry out these tasks. During the strike, the prison staff carry out this work. On a scale to 1 to 10, how safe is a prison currently? A prison is a facility that is housing persons who have committed crimes. As broken down in the initial presentation I presented, the types of crimes committed by the population at Harvey Bay varies in severity, including murder, rape, armed robberies, and the list goes on. As such, the facility remains one with high risk. This is why the committed personnel do their best on a daily basis to maintain safety and security while catering to the needs of the inmates. As per the recent strike, steps have been taken to mitigate and restore order. What is the opinion of the Dutch government still working with UNOPS, given the S31 scandal? As I mentioned earlier, these questions were, the answers were provided by UNOPS, and so I will relay same. Let me see. Yeah. During January 2023, UNOPS Executive Board in New York, the Kingdom of the Netherlands, jointly with Australia, Austria, Canada, Denmark, Finland, France, Ireland, Italy, New Zealand, Norway, Spain, Sweden, Switzerland, Turkey, the United Kingdom, and the United States of America and Germany delivered a statement supporting the UNOPS efforts to the Super S3I crisis. We appreciate the efforts undertaken by UNOPS senior management and the willingness to improve and resolve all the identified issues and reform, refocus, and rebuild the organization. The response and its accompanying online monitoring platform contribute to an indispensable level of transparency. We see it as a confirmation of UNOPS wanting to do things differently. We remain committed to supporting UNOPS in its reform to become a more diligent organization, and we recognize that UNOPS is on a good path. This was issued on the 31st of January 2023 in New York. Under this context, we appreciate the opportunity to continue working with the Kingdom of the Netherlands in such an important project, stated UNOPS. Can UNOPS explain how is it that $61 million could have been given to a single British family? Can UNOPS guarantee that this will not happen in St. Martin? UNOPS response: throughout 2022, under the guidance of its executive board, UNOPS worked closely with relevant stakeholders to address failures associated with the former Sustainable Investment in Infrastructure and Innovation S3I initiative. In November 2022, following a series of decisions issued to address the situation, a comprehensive response plan was initiated to undertake a range of strategic and administrative reforms, including a reset of its organizational strategy. All the information related to the S3I initiative and the actions implemented during last year is publicly available on UNOPS' website. UNOPS is currently implementing a 10-point action plan permanently monitored by member states, including the Netherlands, to improve UNOPS procedures so that it does not happen again. Can UNOPS provide a detailed breakdown of how they plan to facilitate the new construction? UNOPS is currently engaged in phase 1 of the project, which entails the development of a comprehensive program for the prison facilities, as well as the designs which will inform the construction in the second phase. These designs will in turn determine the construction method required to achieve the expected results during the second phase. This all is included in phase 1, plan of action that can be shared if desired. Mr. Chairman, through you, I would move on to the answers to MP Peterson. Is there a doctor or nurse on call within an hour or two in case anything urgent happens and someone needs medical attention? Yes, the nurse is on call during out-of-office hours and makes direct contact with the doctor during emergencies to assess the matter at hand. Test phase telecommunication. What is right now the exact situation for inmates being able to contact their loved ones? I understand at this moment there's absolutely no privilege. Some clarity on this matter. As mentioned in the previous presentation, all inmates have the right to communicate with family members and or their loved ones. For this reason, every inmate has scheduled days and times that they can make phone calls. The officers record all the names of the inmates who wish to make a phone call daily. Inmates who register for phone calls are not restricted from making these calls unless for safety reasons, this call cannot be granted. Inmates make use of a designated landline rather. The test phase of the new telephone system took place yesterday, which was deemed a positive one. The phone was tested in different areas in the prison for signal. Based on the assessment, a number of electrical and connectivity adjustments needs to be made. This is still in process. There are reports coming from inmates that although renovations have been made, it does not mean that they can use the facilities. Sewing room has no equipment to work with. The facilities that have been renovated are all accessible to the inmates that are required to be there at any given moment. The gym is open to all inmates during their air breaks. This is on a daily basis, twice a day. The sewing room is also accessible to those inmates that have signed up for the sewing classes. The sewing room is meant for instruction purposes, and with this in mind, has enough material to teach inmates several sewing techniques. In terms of material to commence with large productions of uniform for inmates and staff, that is not available at this moment. In the past, material was bought from overseas, considering the large difference in price compared to local sourcing this material. However, due to the material being bought overseas, there were no opportunities to carry out a quality control of the material, which led to a large amount of the clothing being unfit for use. The prison is currently searching for material that can be bought locally, and quotations have been requested. We are scheduled to receive sample cloth next week, upon which we can place an order if approved. However, currently there is enough cloth to provide inmates with sewing lessons. One point I want to also add to this here, right, is that in a previous time that I was asked this question, I made mention about the fact that the sewing room is a program that comes with sharp objects, that scissors and these things. And so we have to do a proper assessment, just like the kitchen, which inmates are allowed to participate. And if you have inmates that are denied due to their behavior, their outbursts, their state of mind, their behavior, as I've stated, they will indeed be denied the ability to have access to such programs. It does not mean that it is not operational. What are the minimum requirements for staff? How many guards should be placed at what times? Are these requirements being met? As mentioned above, currently of the 64 persons that are employed at the prison as guards, 43 are deployable. The remaining number of guards are on long-term sick leave or have been transferred to other departments over time. So we are busy taking steps to be able to mitigate the shortcomings in our current structure. Through you, Mr. Chairman, I move on to answer questions, that of MP Wescot-Williams. Can I have a clear overview of the current issue with respect to the staffing at this moment? The Point Blanch Prison has long suffered from structural understaffing. As you know, the shortage of staff is caused by persistent absenteeism. On one hand, it is largely determined by the long-term sick leave employees as well as frequently absent employees termed the frequent flyers. On the other hand, the understaffing is determined by employees working elsewhere within the justice chain, as prison guards have been transferred to other justice departments. These transfers are usually granted by request due to various reasons expressed by the employee. The employees concerned all come from the formation and budget of the prison. without any compensation and adjustment in the formation. The years of structural understaffing take a heavy toll on the remaining and incumbent staff, resulting in extra overtime, fatigue, insecurity for staff, absenteeism, physical and mental weariness, and more. In addition, apart from the high absenteeism rates, which are nearly embedded in our culture, the guards all receive different levels of training. After 10-10-10, there have been 2 groups of guards that followed a training, both that did not fully complete the training administered. This presented a challenge as well, as the guards were not all trained to take on all the tasks at hand. This type of inmate has also has drastically changed, or the types of inmates have drastically changed over the years, with younger and more aggressive inmates that are incarcerated for more heinous crimes. This also requires a different skill from prison staff. As mentioned before, the prison guards are currently undergoing a training which will serve as a starting point for all guards. They will acquire the same level of skills, knowledge, and will be able to execute their task with more confidence. I want to hear from the Minister the issue of placement pertaining to prison guards, as well as the general issue placement in the entire Ministry of Justice. I don't have the date per se with me, but the LB for the placement committee as well as the appeals committee were signed by both my person and that of His Excellency Governor Bailey. The placement process for the Ministry of Justice is therefore underway. Within the coming weeks, the employees will be receiving their letter or offer letters. In that overview, please also speak to the issue of overtime payments, especially with the seemingly chronic short staff at the prison. Overtime payments to employees at the prison are paid on a monthly basis. Once an employee has worked their overtime hours, it is controlled by their supervisor and then sent to financial controllers to be paid. I can't put my finger on where the issue is with respects to the payout of the judicial workers, specifically the matter of communication between the Governor's Office and the Council of Ministers. What was sent to His Excellency and what has been requested from the government in order to sign off on what has been sent to His Excellency. The legal documents that were sent to His Excellency, the draft legal position regulation of the police officers on December 9, 2022. This came along with the national decree with general measures to be able to establish the legal position or the police law, the national decree for the new police scales, and finally the national decree in connection with the activation of the approved function book of December 28th, 2021. The Ministry of Justice received an advice requesting the full debt amount owed to the personnel, and a calculation has to be done as to what is owed retroactive, as well as in conjunction with or in honoring the new function book, what the country would be subject to pay going forward. Those calculations are in their final phase, to the point where RPS is now receiving the files of each agency to be able to execute their component in this process. Once RPS has concluded, as we have already had the input of the tax department and SEDV, once RPS has concluded, the file will then go on to SORB for a proper audit to be done. The audit is necessary as we would want to ensure that the figure that is being presented to His Excellency, along with the mentioned decrees, are all with accurate figures. At this time, we cannot provide any numbers, but I think that question is asked lower down. I would like a clear understanding of the whole financing of the payments to our justice workers. As previously mentioned, the total sum of cost of the placement process is needed for the approval. It would be premature at this moment to mention a total sum, as parties such as RPS is now going to commence their handling with the files. After completion of the respective authorities, the process will be audited, as I just mentioned, by SORB prior to issuing any disbursements. Once the final number, along with what those annual installments amount. And when I make the mention of the annual installments amount, I'm referring to the agreement, the covenant agreement that was signed between the minister and the unions, that these installments would take place within 3 to 5 years of installments. Those figures would be identified and a formal announcement will be made. Finance, we have an issue with our budget. 2022 budget passed with contribution to new prison. That 2022 budget was objected by the CFT. When you don't have a budget for the year, you rely on the budget of the previous year. What budget are you using? What does it mean when CFT disapproves of the budget of the year? What is our financial instrument at the time? The national ordinance establishing the 2023 budget has not been entered into force. Therefore, there is no basis for the 2023 budget for entering into the financial commitments. Pursuant to Article 14, Paragraph 6 of the Financial Supervision Act, the Article 16, Paragraph 3 of the Accountability National Ordinance, in that case, the budget of the previous service year as the basis for management to keep the service going. With regards to the question when it comes to, so there's no necessary contribution at this time for St. Martin from that budget. I believe there's a follow-up question that will give a little bit more insight specifically with what contribution St. Martin has. Here it is. What is the current agreement between the Netherlands and St. Martin as it pertains to the financing of the new prison? Has costs already been made, and where are those costs allocated to? What is the current state of financing agreement? Have expenses been made? How much and whose side of the budget has it fallen, St. Martin or the Netherlands? And this is what I was saying earlier in terms of any type of relevance to our budget situation. The cost of phase 1 of the St. Martin Rule of Law facility with a duration of 20 months is budgeted at 3.9+ million. Phase 1 is fully financed by the Netherlands. As such, no payments for phase 1 are on the end of St. Martin. Again, I'm stating that because in the previous it was queried about, you know, the difference in our budget and where we are there. So in the event that the question was being asked to understand that if St. Martin has to contribute at this time, how will we do so in the current budget? This answer is catering to that as well. The Netherlands government, as co-financer of the new prison project, has pledged 30 million euro to St. Martin, 20 million euro for the building of a new detention center, and 10 million euros spread out over 5 years for the structural improvements of the detention conditions in St. Martin. As it stands now, St. Martin will have to finance the remainder of the total cost of the new prison facility, which will become known at the end of phase 1 of the project, which will last for 20 months. Is there any other assistance to the prison in terms of security and any other than the WKS? If so, how much and at what cost? No, WKS is the only third party that is assisting with security, as I mentioned earlier, the parameters at the prison. How does the minister assess the public statements made by the lawyer? How does the minister assess the two? What is being done in response to these statements? What is the minister's position in this? Where do we go from here with the situation that is happening right now? How does she plan to tackle it? I believe that quite a number of responses, both internal and publicly, have been issued, not only by my person, but that of the director. And even here in Parliament, we have presented a presentation that gave in-depth updates about the positive things that are happening at the Point Blanch Prison. All aspects of the logistics and steps that will be taken to mitigate the matter that is currently happening at Point Blanch Prison, of course, for security reasons, cannot be shared. However, I assure you that the necessary steps to maintain the safety and security of all persons are being looked into. We are taking all the steps that we need to safeguard everyone as much as possible. We are doing everything that we can to hear out the inmates, even on a one-on-one basis, so that they can express themselves, and all the necessary steps to be able to ensure that grievances are met as much as possible, are being executed. How hard is the obligation of the ministry to keep convicted persons and persons in pretrial detention separated? How strong is the legal basis mandate that the minister can keep, that the ministry or the minister has to keep that separation? Or is there some flexibility in placing the inmates? Article 4, in conjunction with Article 5 of the National Ordinance on Prison Principle, provides the Minister of Justice with flexibility and the placement of pretrial inmates with convicted inmates. House rules. Do we have the updated rules that regulate the rights and procedure regarding inmates? When is this dated? The House rules have been amended in 2022. The prison director established the new House rules, and these have been disseminated amongst the inmates and staff in October 2022 in English, Dutch, and Spanish. Compared to the previous version of the House rules, a substantial number of amendments have been made. Firstly, outdated information has been removed and replaced with accurate information, for example, about conditional release. In addition, more elaborate information has been included on certain subject matters, such as visits, rights of inmates, personal belongings, and the use of cell space. And finally, new information has been added on different subject matters, such as prohibited items, electronic devices, and hourly rates for labor by inmates. As I indicated previously, a copy of this can be provided to Parliament should it be desired. How does the staff shortage after the non-essential service such as educational and recreational services? If you don't have enough staff to carry out the guarding, how can these other things happen? The beautiful thing about this, Mr. Chairman, is that the experience thus far in these environments mentioned, such as the education and recreational spaces, are peaceful and filled with inmates who have only one agenda, and that is to learn and be productive. As such, even with a limited staff, these programs have been running quite positively. Once again, we are extremely appreciative of Climb Foundation, the staff and inmates who participate in contribution to the success rate of our education and recreational programs thus far. Just want to reiterate that we had our first graduating class on GED. At least 6 inmates have successfully completed this thus far. The work that those inmates have been assisting with, how is this affected by the strike? The inmates are usually the ones doing this. It is ultimately the prison's responsibility that the necessary work is carried out. Under normal circumstances, inmates are assigned these jobs in the kitchen, maintenance, cleaning, and so on. The strike inhibits those inmates who are eager to work from working as per instruction given by those leading the strike. This has a negative effect on those who depend on their jobs for funds to spend at the canteen. Ultimately, no work means no pay. This also has effects on the prison, as additional costs needs to be incurred, such as additional kitchen staff from employment agencies to get the work done. Human rights. With respect to human rights, and we have had several cases of human rights or the lack thereof being challenged. Are there any such challenges pending right now where, because of the conditions or whatever, the government of St. Martin, and we have been where that has even in some instances has stretched to the kingdom or the Dutch government? Are there any such challenges hanging somewhere right now? Are there any updated prison visits that have taken place by, for example, or to be taking place shortly? By, for example, I think the correct acronym is the CPT. Is there such a visit pending? Is there such a report? Where do we stand where that type of assessment of our entire prison operation is concerned? Through you, Mr. Chairman, I can inform the Honorable MP Wescot-Williams, Parliament, and the listening and viewing public that there are currently no court proceedings regarding any human rights violations in St. Martin being handled before the Grand Chamber of the European Court of Human Rights, or ECHR. I do not have any information on whether any cases or challenges will be brought to the ECHR and how likely it is that these will be heard, because the ECHR has an entire process whereby it determines the admissibility of the applicant or the complaint before they take a case into consideration. A delegation of the Council of European Committees for the Prevention of Torture and Human or Degrading Treatment or Punishment, CPT, carried out a visit to the Kingdom of the Netherlands from the 10th to the 25th of May 2022. The visits concerned the Netherlands as well as the Caribbean countries of the Caribbean, Aruba, Curacao, and St. Martin. In the course of its visit to St. Martin, the CPT delegation examined treatment and safeguards afforded to persons deprived of their liberty by the police, as well as treatment of persons in prison and their conditions of detention. The delegation visited the Point Blanch Prison, Phillipsburg Police Station, the Simpson Bay Immigration Detention Facility, also referred to as Gens Hospicium, was also visited to examine the situation of persons deprived of their liberty under immigration legislation. Following this visit, a report was drawn up by the CPT, which includes various recommendations, comments, and requests for information. The report, which is currently confidential, requests the Kingdom government to provide within 6 months a response giving a full account of actions taken to implement the committee's recommendation, as well as reactions and replies to the comments and requests for information formulated in the report. In coordination with other countries of the Kingdom, St. Martin has started formulating its responses to the recommendation, comments, and requests for information. Within the next few months, CPT will publish this report. Until then, no specifics can be shared. UNOPS hopes that agreements is still standing considering the dilemma of St. Martin's budget. Yes, the agreement still stands. Through you, Mr. Chairman, I now move on to the questions you put forward as MP Bryson. Can the Minister clarify how current were the pictures? We deserve an honest and open picture. Additional context needs to be given to understand, were we looking at things right now or from a while ago? The photos, as shown in the previous presentation, all date back to the year 2022. The gym equipment arrived in February 22. The gym was renovated in the first quarter of 2022, mainly by the inmate maintenance team. The computer room was officially reopened in April 2022. The inmates repainted the walls and all the computers were provided. The actual classes also started in April and went on until December 2022. All inmates were given the opportunity to participate in the GED classes, to which only 11 inmates joined. And I say this, Mr. Chairman, through you, that it is unfortunate with the statements that have been made to the public, painting a picture as though no courses are being offered. This is just absolutely not true. Nevertheless, we continue to encourage all inmates to participate. The GED classes for the year of 2022 ended in December 2022. The services was retendered for 2023 to 2025. This is currently taking place, and the prison hopes to have the educational services back up and running by March 2023. Other infractual renovations. In the photos, you can see that the airspace, the barber shop, the recreational room, the staircase, the outer walls, and more were renovated. This all took place as of July 2022 and onward, mainly also executed by the inmate maintenance team. The temporary chapel was erected for the first time in October 2022, which usually takes place every Sunday. Unfortunately, due to some heavy winds in January of this year, the tent received some minor damages. These are being repaired to restart the services as soon as possible. Staffing. Very concerned about the situation with guards. Has Minister considered discussing with SZV and AVBZ provisions for long-term sick leave? Can the Minister consider this? Yes, Mr. Chairman. These efforts have been on the way with the services of MedWorks, who carries forward assessments that are not available under the service umbrella of SZV. As previously mentioned, an exercise to legally and structurally address this matter will commence directly after the placement process. Prison Law, Article 8. The detainee shall be examined by the institution doctor as soon as possible, but in any case within 24 hours of his admission, his or her admission. Is this in place? This question we did give some details with, but I'll go back into it. Though they may not have been evaluated by a medical doctor within 24 hours of arriving at Harvey Bay, they do go through a medical evaluation by a medical doctor prior to arriving at Harvey Bay, and this is done at the Phillipsburg police station. But then upon arrival, each inmate to Harvey Bay, the nurses carry out a brief medical assessment. This includes discussing the current medical issues or important medical history that require follow-ups or impair the inmate. A follow-up in-depth assessment is carried out within 1 to 30 days upon arrival. The in-depth medical assessment includes a visual observation, general assessment of medical history, medical health assessment, and blood tests, which generally includes an HIV screening. However, there have been challenges with carrying out blood tests at the lab for inmates who are not in possession of valid identification. This is a requirement to carry out the lab tests. The blood tests are not mandatory and are carried out on a voluntary basis only. It is in the prison director's intention this year to increase the focus on medical care at the prison. His plans include refurbishing the medical room as well as updating the medical protocols such as the medical intake as described above, medicine distribution, and more. In the event that the nurse ascertains a medical injury and or condition that needs to be tendered to by the doctor, they are referred to by the doctor who does the follow-up consultation and treats the inmate. The doctor is present on a weekly basis and is on call for emergencies that require the doctor's services. Prison Law, Article 13, an institution employs one or more spiritual counselors and social workers. Is this in place? Currently, there are 2 social workers employed full-time at the prison who are present 5 days a week. The inmates have the opportunity to book a consultation with them on a weekly basis. In addition to prison has spiritual counselors. There's a list of 4 pastors that rotate weekly from different denominations. Personal requests by inmates with pastors can be granted. Prison Law, Article 20, Sub 3. The performance of work outside the institution only takes place after approval from the minister and under the conditions to be set by her. Is the Minister of Justice willing to grant others to work within public work? If so, what are the steps needed to have inmates work in public works? Yes, myself and Minister Vromi initiated the activities of our representatives within our ministries, and they are busy discussing the work program for inmates to clean the roadways, erect road signs, and so forth. With the assistance of the electronic monitoring system and under the supervision of the prison personnel, the prison management is currently in the process of surveying or processing a review for the following stages for eligible inmates to participate in this collaborative program as a pilot. In addition to the amount referred to in Article 21 and 22, the detainee may receive from third parties a maximum of 500 guilders per calendar month or the equivalent. May I get clarity on the 500 guilder and the purpose of it? Is this for canteen? Can that be modified, and is it still considered sufficient considering price increase? The amount is transferred to an inmate's zakgeld or pocket money account, which can be used for the purchase of canteen articles as well as for other purposes. In order for this to be changed, of course, we would have to do a proper assessment, and it would have to be done so via an MBA, an Amendment 2. One hurdle that is seen is the VOH or police record. Those that come out after paying a debt to society but still have a police record. Is there some way where these merit certificates can be listed within the Justice Ministry while incarcerated? They worked on becoming better part of society. Recreational and reform activities must be documented, either within the VOH procedure or some other form of justice procedure to document the recreational reform activities that the inmates are participating in. The Ministry of Justice is fully aware of the challenges that inmates can face after their release from the prison and will continue to take initiatives to better their chances of a successful rehabilitation and resocialization. The copies of certificates of completed courses are kept in the detention file of an inmate. In addition, the social workers register in what types of activities, such as education, rehabilitation, labor, they are participating in. However, there is no legal basis to include this type of documentation into the screening process of a VOK. Moreover, it is always up to the employer to determine if a VOK is necessary, and of course, those certificates during an application process or an interview process are shared with potential employers. In regards to UNOPS, in the aspect of the finances, has St. Martin paid anything as yet? Where are we with allocation? Is there still room to negotiate this with the partners of the Netherlands and UN, considering the precarious financial situation we find ourselves in? Also, in the inclusion and ability, how involved with our locals be part of this project? What is the emphasis to include local expertise for St. Martin? This question is in part similar to a question posed by the Honorable MP Wescot-Williams. The cost of the phase 1 of St. Martin Rule of Law facilities with a duration of 20 months is budgeted at 3.9+ million. Phase 1 is fully financed by the Netherlands. As such, no payment for phase 1 is to that of St. Martin. The Netherlands government, as co-financer of the new prison project, has pledged 30 million euros to St. Martin, 20 million euros for the building of the new detention center, and 10 million spread out over a 5-year period for the structural improvement of the detention conditions in St. Martin. As it stands now, St. Martin will have to finance the remainder of the total cost of the new prison facility, which will become known at the end of phase 1 of the project, which will last for 20 months. And finally, through you, Mr. Chairman, I have a question from MP Pantaflet. Hiring of infrastructure expert, that is still lacking. Very important position that should be filled. The answer is that this question has been noted and UNOPS is well underway in filling this crucial position. Through you, I have a question from MP Rumu, Mr. Chairman, and it is the ministry exploring the education program to include soft skills, entrepreneurial skills, resume writing, and more? The first goal was to restart the educational program so that the inmates would have the opportunity to obtain, at minimum, a high school degree. During the final stages of the GED pilot, we surveyed the inmates who participated to inquire what other programs they would be interested in. This indeed showed that the inmates are interested in multiple other courses, online and physical. These additional courses can be explored with multiple organizations such as NEPA, Probation Services, St. Martin Development Fund, and possible other private companies. These options will be explored in the first quarter of 2023. Mr. Chairman, through you, I have a few closing remarks, if you would permit me.
We are still within the first round. Is it related? Is it not a closing remark? Is it let's say, a response in terms of questions asked?
I'll wait until you give me the opportunity.
So then, yes. For now, it's just to answer the questions.
Good. Thank you.
Members of Parliament, Honourable Minister, thank you for the answers to the questions that you've provided thus far. Thank you for the answers to the questions you provided thus far. It is now 12:22. And we do still have to go into clarification, but I would like to adjourn to give members of Parliament an opportunity to have lunch as well. Therefore, I would propose 1:30 should be enough, 1 hour. I see MP Wescot-Williams.
Mr. Chairman, with your indulgence, a proposal of order, and can we, depending on the amount of requests for clarification, maybe give those so that they can be worked on during the lunch pause as well? I have like 3, not more than that, and so then we give it to the minister and her staff, and they can start to look at those while we have adjourned. Thank you, Mr. Chairman. Just a proposal of order.
Sure, I thought about that, but being that there were so many questions, maybe I might have incorrectly assumed that there would be many clarifications. And I know one speaker also mentioned who had many questions was going to have to leave. So if all members of parliament are okay with being able to complete their clarification round, if not, I want to ensure I afford everyone the sufficient time and opportunity to ask their clarifications. But being that some members who spoke do have to also leave and it's fair for them to get a lunch break, I would then say, no, let us adjourn now, return at 1:30 with the clarifications, and hopefully Minister can quickly answer the clarifications and we go straight into the second round. Okay? So members of parliament, we'll adjourn until 1:30 p.m.